Dear students, welcome to the video lecture for the subject property law. Today we will be dealing with the topic gift. I am Lalith Kumar, Assistant Professor of Law, Bharat Institute of Law, Bharat Institute of Higher Education and Research. So first we will look into the definition of the topic gift, which has been defined under the section 122 of Transfer of Property Act 1882. So first, we will look into the definition. So according to section 122 of the Transfer of Property Act 1882, gift is defined as the transfer of certain existing, movable or immovable property made voluntarily and without consideration by one person called the donor to another called the donee, and which is accepted by or on behalf of the donee. So one difference which we could easily see in this definition is that gift consists of both the existing movable as well as immovable property. So if we look into the historical background of the Transfer of Property Act 1882, Transfer of Property Act 1882 was mainly legislated for the purpose of immovable property, because at that period of time we had the Indian Contract Act 1872, which dealt with the Sales of Goods Act. I mean, the concept which comes under the Sales of Goods Act as of now was initially in the Indian Contract Act 1872. So Contract Act dealt with the movable properties. So at that period of time, we had a lacuna of the immovable property. We didn't had any specified law apart from the precedents of the English courts and all. We didn't had any law, any particular law which dealt with the immovable property. So at that time, the Transfer of Property Act 1882 as well as the Indian Easement Act 1882 was legislated, was passed by the Parliament. But there are few sections in this act which also deals with the movable property, and one such section is the concept of gift, that is section 122. So if we look into the definition, it clearly says it shall be an existing one, an existing movable or an immovable property, and which shall be made voluntarily. So the property in the nature of future, a property which you may incur in the future, shall not be given as a gift. You can give the property which is existing in nature as on the date in which the gift deed is made. So we will look into the essentials of gift, which has been derived from the definition itself. So we will look one by one. The first one is there must be a transfer of property. So according to section 5, which defines transfer of property, so here it is, there must be a transfer of property. So actually the Transfer of Property Act deals only with inter vivos transfer, that is transfer between two or more living persons. So if any transfer is made in which one person is alive and the other party is not alive, will not come under the purview of Transfer of Property Act 1882. Those transactions are called as testamentary instruments, and those will come under the Indian Succession Act or any other law as per the religion or as per the cases concerned. So Transfer of Property Act deals only with inter vivos transfer, that is transfer between two or more living person. So here one of the essential is there must be a transfer of property. So the transfer of property shall move from person A to person B, and when it moves, so then only we can call it as a gift. And the next is the property must be an existing one. So the property which is being transferred from person A to B shall be an existing one. We had already seen under section 6 of the Transfer of Property Act, which the nomenclature of the section says what property may be transferred. And when we go inside the section, it says property of all kind can be transferred except, and the exceptions are given. And one such thing is spec successionis, which says any property which you may incur in the near future or which you feel that you will incur in the future. So let's say person A believes that his father's property will come to him. Let's say he is the only child of person A and he believes that he will get the property. So with such belief he cannot enter into an agreement. So let's say the son enters into an agreement with C stating that I'll get the property or I'm the owner of the property and he's selling it off. Such transactions are not valid because you may incur it, you may not incur it. The person A may give the property to someone else also, or he may give it to some trust, or he may just like sell that property as per his wish. So such transactions in which you feel that you will incur it in the future, you cannot make a transaction. Same applies for gift also. It is clear that a property must be an existing property. So future property nature, any transaction in which the nature of the property will come to you, you will get the ownership or you will get the possession in future. You cannot make a gift out for that. And the transfer must be without consideration. So we had already studied the Indian Contract Act. You would have already studied the Indian Contract Act, where you would have gone through the essentials of the Indian Contract Act under section 10, which says there should be an offer and there should be an acceptance, there should be a consideration as such. The consideration which we have studied till date means only the monetary transactions, the monetary types or the monetary values. But as of gift is concerned, the consideration is more of like a love and affection one. The moment you make a transaction with monetary value, then it becomes sale. You're making or you're selling your property or you're giving the ownership from person A to B with, let's say, 1,000 rupees, for example, then it is a sale, it is not a gift. So as of gift is concerned, there shall not be any monetary value. There shall not be any consideration. It should be made without consideration. And the transfer shall be made voluntarily. So there shall not be any fraud, there shall not be any undue influence done by the donee to get the property from the donor. So the person who is making the gift is called as the donor, and the person who is going to receive the gift is called the donee. And the gift must be accepted by the transferee, that is by the donee. The donee shall accept the gift. So it is not that if the donor writes that I want to give this property to so and so, the deed is executed. It is not so. The donee shall accept the gift. So we will come across the sections why it is made voluntarily or why it is not made, why it is not made voluntarily, that once the donor gives the gift, the donee has to accept it. Because if there is any burden, that will also come with the benefit. So you cannot just like that enjoy the benefit in a property and exclude the burden in a property. So we will come across those sections in the next few slides. So I hope the definition is clear. So as of the consideration which I was telling you, that a gift is a transfer of property without any monetary consideration by one person in favor of another and accepted by him or by any person on his behalf. So transfer without consideration. So these transactions, these transfers are called as gratuitous transfer because these transfer does not contain monetary value. These transaction does not contain any consideration. These transactions are made without consideration. So they're called as gratuitous transfer. So gift inter vivos is a gratuitous transfer of ownership between two living persons and is a transfer of property within the meaning of section 5 of the Transfer of Property Act 1882. As I said you, section 5 deals with what is transfer of property. So though it is without consideration, but still gift comes under the purview of the transfer of property under section 5 of the same act, the Transfer of Property Act 1882. So gift testamentary, if any gift which is in the nature of testamentary, so gift testamentary is called as a will, which is a transfer by operation of law, and it is outside the scope of this act. So as I said you, any testamentary transactions, any transactions where the transaction could come into effect or the transaction could be executed only after the death of the transferor, then it will become a will, or it will become a testamentary statement or a testamentary instrument, and it will be applied by the Indian Succession Act or any other law, but it will not come under the purview of gift. So let's say a person A makes a gift to person B on, let's say, 1st Jan, and let's say that offer or has been made to person B, stating that I would like to gift my property, so and so property, to you. And let's say B thinks on that, and let's say A dies on the 5th of Jan. So after 5 days, after he makes the offer, he dies. And let's say on the 6th of Jan, without the knowledge of the death of A, B sends his reply stating that I would accept the gift. The gift is not valid because both the persons should have been alive on that period of date, on that particular date. Both the persons should have been alive, the donor as well as the donor. Because this comes under Transfer of Property Act, the inter vivos transfer. So if you want to execute such gift where a person wants to give so and so property but he has died, then it has to go through the testamentary instruments. The Indian Succession Act, the person A can write a will and keep it, and once he dies, it will be executed on behalf of person B or whichever person A would like his property to move with. Okay. So this is as of the essential as well as the definition is concerned. And one more thing which is there, one of the important element of the gift is concerned, is the donor must be a competent person. So the person who is making the gift shall be a competent one. So the donor is the person who makes the gift, as I have already said you, or we can even call him as a transferer. So in a transaction by way of gift, the transferer is called a donor, and he divests his ownership in the property so as to vest in the transferring, so as to transfer the vested interest in the property to the donee or to the transferee. So he must have therefore attained the age of majority. So you have to look into the Indian Contract Act, which talks about the competency of a party to enter into a contract. So he should have been a major, he should be a sound person, he should not be lunatic, he should not be insane. All these persons are competent to enter into a contract. So in the same way, the donor shall also be a competent person to make a gift. What about donee? So let's say the donee is a minor, and a person who is a major, or let's say the donor wants to make a gift to a donee. Now who will accept the gift? Because the donee is not a competent person to enter into a contract because he is less than the age of 18 or attaining the age of majority. Then in such cases, what happens is the legal guardian of the minor will accept the gift. And does it travels with the minor for his life now? No. So what happens is, when the minor or when the transfer is made, the guardian or any person on behalf of the minor will accept the gift. And on the date when the minor becomes major, he gets a right to either accept the gift or to deny it. So he can either says yes for that gift and he can enjoy the benefit, or if any burden is there, he can enjoy both the things. He has to face both the things. But if he denies it, the property moves back to the donor. And let's say the donor is not alive at that period of time, then to his legal heirs, his or her legal heirs. Okay, so there shall be a competency as of the donor is concerned, and as of a donee is concerned, even though if he is a minor, some person on his behalf can accept it. That's why we have seen the last essential element, that the gift must be accepted by the transferee or anyone on his behalf. So any person can accept on behalf of the minor or on behalf of the donee when they are not competent to enter into a contract. But the moment they become entitled, the moment they become a competent as of the law is concerned, they get a right either to accept it or to deny it. So next we will see how a transfer is effected, how the transfer takes place. So this comes under section 123. It says transfer how effected. So as of an immovable property is concerned, it is only through registration. So the act makes it very clear under the topic sale, where it clearly says that any property worth more than rupees 100 shall be transferred through a registered document only. So any property, any immovable property to be more precise, any immovable property worth more than rupees 100 shall be made only through registration. So you have to follow the Transfer of Property Act. section 54, 55, which talks about sales and all, and also the Stamp Duties Act, and as well as the Registration Act for the state which is applicable for that particular transfer is concerned. So what it says very clearly, more than rupees 100. So when this act was enacted, that was an amount because it was enacted in the year 1882. So in that period of time, you could have easily gotten, you easily got a property less than rupees 100 also. But as on date, it is not possible to get any immovable property less than rupees 100. So any immovable property, by default, it is that it has to be transferred with the help of the registration alone. So same applies for gift also. But as we have seen that gift also talks about the movable property, then what happens? What happens if a gift is made for a movable property? Then the section says that the gift may be completed by delivery of possession and the registration is optional, not compulsory. So there is a chance, there is a choice which the donor and the donee can make. If they want to make it through registration process only, they can go for that. They can go and execute the gift deed. But if not, they can just make it by the delivery of possession. So let's say he wants to gift his mobile phone. Person A wants to gift his mobile phone to person B. He can just hand over the possession to B, and the moment B gets the possession, he becomes the owner of the property. There is no consideration. He has just given out of love and affection. So he can enjoy the property. What happens if he's giving the same mobile phone for an amount? Let's say he charges them some 5,000 or 10,000 rupees for that particular mobile phone. Then in that case, we have to go and refer the Sales of Goods Act, because sale here does not talks about the immovable property. It talks only about, sorry, it does not talks about the movable property. I'm sorry for that. Sale does not talks about the movable property as of the Transfer of Property Act is concerned. We have to go and refer the Sales of Goods Act for the immovable property. Next, we will see section 124 and 125. So section 124, which is the gift of existing and the future property. So where a gift is made, of two properties, of which one is existing at the date of gift, but the other is not. So we have seen in the definition itself clearly stating that the gift shall be made of an existing property. So section 125 contemplates that, 124 contemplates the same thing, and it says that what happens where a gift is made of two properties in which one is existing at the date of gift and the other is not. The whole gift is not void. So let's say you're making two gifts, property A and property B. Property A is existing on that date and property B is a future property which you may get or you may not get. The donor may get or the donor may not get the property B. So he has made two properties as a gift in a single transfer. Section 124 clearly says that the whole gift is not void. Only the part which relates to the future property is void. So there are two transfer, property A, which is existing in nature, property B, which is future in nature. So what section 124 second part says, the property which relates to future property is void. So the one which is existing in nature is valid. So property A is valid, property B is void. You can accept property A, you can enjoy the benefit. There is no need for you to worry about property B because it is not existing in nature. It is future in nature, so it does not come under the purview of gift as per this act. And what happens if a gift is made to several persons? If a gift is made to one or more person, then section 125 talks about that. So 125 says that where a gift is made to several donees, of whom any one donee does not accept the gift. So a gift is made to several donees, and out of which one donee does not accept the gift. So let's say if a gift is made to person A and person B, then what happens? Then, and one person, let's say person A is not accepting the gift and person B wants that gift. So section says that the gift on his part only is void. So if person B does not wants the gift, and he, let's say he rejects the gift, or he says, or he denies to get the gift, then person A wants the gift, or let's say person A accepts the gift, then he can enjoy the gift. He can get the gift, and as of B is concerned, as such, there is no transfer has been made. It will be deemed that as such no transfer is made. Or let's say the gifts in favor of other donee stands valid. So the gift which has been made for other donees stands valid. Or let's say in a single transaction, let's say property A, B, C will be given to X, Y, Z. So let's say person, let's say person H wants to sell off his three properties A, B, C. Sorry, wants to gift his property A, B, C to X, Y, Z. Now what he is doing is he is making in a single transaction. So he is telling that property A will go to X, property B will go to Y, property C will go to Z. And let's say X does not want that gift. So, but Y and Z are ready to accept the gift. So the transfer or the gift made for Y and Z is valid, and the transfer made of property A to X is not valid because he is not accepting the gift. So the whole context is that as of gift is concerned, if one person does not wants the gift, or if in a single transaction 2 or more persons have been given the gift and one denies it, or let's say in the same example, let's say there is only one property A alone is there, and he is giving it to 3 persons X, Y, Z, and let's say in that X does not wants the property, so he's giving, so they will divide it into 3 and enjoy the property. But person X says, I don't want that property. So what happens? Y and Z will get that property and they will divide it into 2 and enjoy the property. Okay. Next is suspension or revocation of gifts. Sorry. So section 126 of the Transfer of Property Act deals with when gift may be revoked or suspended. So according to it, the donor and the donee may agree. So the first part is revocation by mutual agreement, and the second part is revocation by rescission of contract. So the first part is revocation by mutual agreement. So according to it, the donor and the donee may agree on that on the happening of any specified event, which does not depend on the will of the donor, a gift shall be suspended or revoked. But a gift in which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or in the part as the case may be. So it says that if you're making any gift, but you want to have a mutual agreement with the donee also, that if so and so situation happens, if that specified event happens, then the gift must be revoked. So let's say person A is gifting his property to person B with the condition that B shall marry C. So if B marries C, he enjoys the property. And let's say after receiving the gift, B marries D. He has breached the condition. Then what happens? The gift becomes void. The property goes back to A. But the section also says that if it is on the part of the donor or it is at the will of the donor, then those conditions are not valid. So person A is making a gift to person B with the condition that if A marries C, the gift is void. So it is at the will of the donor. Now it is up to A whether he wants the property or not. So let's say if he wants the property back, he will go and marry C. He don't want the property, he will marry someone else. So it is at the will of the donor. Or let's say if any one part is there. So let's say he is making two gifts and in one gift, the will of the donor is an essential one. Then that part alone is not valid. The rest of the gift is valid. So we have to see in which part the will of the donor is there. And if there is no part as of the will of the donor is there, only the donee part is there, then it is up to the specified event, the happening or non-happening of a specified event. So we cannot just like that put any illegal agreement, illegal conditions and all. So anything which is legally valid under the law. Under the domestic law, whichever is legally valid has to be put in as a condition. Only those conditions will be taken into effect. Okay. So the condition must be an express one. It should not be merely in the form of a wish and desire. So you cannot just like to say that I was thinking on that, or that was my view, or that was my idea, or that was something in my heart, or that was something in my mind. Those conditions will not take effect in the eyes of law. So the condition must be an express one. It should be laid down in the gift deed itself. So the gift deed in which you're selling, so I mean telling which property you want to gift to which person and by which date and all those things, in the same agreement, the revocation by mutual agreement condition shall also be mentioned if you want to put so. Or let's say you can put it, if he is not taking care of me at my old age, if he does not take care of me, the gift will be revoked. You can put that condition also. But all these conditions should be in express way. It should be expressed, it should be laid down in the gift deed itself. It cannot be merely in the form of a wish or a desire. So that point you need to be more clear with. You cannot just like that say that I was thinking about this, or that was my point of view, or that was in my mind. We cannot just like that say these statements in the court of law. So a gift is a transfer of ownership without consideration. Like other transfers, gift too can be made subject to certain conditions. So the donor may make a gift subject to a condition of it being suspended or revoked. So he can make a gift with the conditions of it getting suspended or getting revoked. But such gifts would then be governed by the provisions of the act. Then those conditions, whether, as I said, whether it is legally valid or not, then those every laws, whichever the section or the condition talks about, will be applied. The provisions of those acts will be applied. Okay. What happens if there is a revocation by rescission of contract? So where the gift is not made voluntarily, the gift must be revoked. So the donor has to prove it. The burden of proof lies with the donor to prove that the gift has not been made voluntarily. The gift has been made by some fraud, by some undue influence and all. And if he proves that, then the gift can be revoked. So it is voidable in nature. So it is up to the donor whether he wants to revoke the gift or not. So if it has not made the gift voluntarily, then he easily say and prove the same, and he can revoke the gift. Because the nature is, as we have already seen, gift is a gratuitous transfer of ownership made voluntarily. And if it could be proved that the gift was not made voluntarily, that is, the consent of the donor was not free, or the gift must be revoked, then the gift must be revoked. So the gift is always preceded by an express or an implied contract. So there is an offer by the donor and the acceptance by the donee. And if the precedent contract itself is rescinded or revoked, there is no question of taking place of transfer of gift made under it. So according to section 126, a gift is revoked also on any of the grounds which it might be rescinded, or has it been a contract. So as if it has been a contract, so we have to apply section 19 of the Indian Contract Act provides that where consent to an agreement is caused by coercion, undue influence, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so obtained. So here it is the donor. So it is voidable at the option of the donor. So if the donor opens up and says that the consent was not made voluntarily and he proves it, then it can be revoked. Or let's say if the donor sits silently, or let's say the donor waives his right, then the contract becomes valid. The contract will take effect as per the gift deed. Okay. Next is section 127, which talks about the onerous gift. So it is based on the maxim, "Piu sentit commendam, sentire det et onus." So we have seen few gist of this particular section before itself in the definition when we were looking into that part, section 122. So it means One who accepts the benefit of a transaction must also accept the burden of it. So any gift which is burdened with liabilities, or a gift of non-beneficial property. So you're getting a gift out of which you don't have any beneficial interest. You're not going to get any monetary benefits out of that property. So let's say I'm making a transfer of a property which is worth 100 US dollars. But already there are lots of dues in the properties. There are lots of taxes or a debt or a loan due and all, which is worth 150 US dollars. Then this gift is called as a onerous gift. So it is not that you cannot accept it. You can accept it, but as we have said, you have to accept the benefit as well as you have to accept the burden out of it. So you might have an idea that, okay, I'm going to get a property which is worth 100 US dollar. Then you have to accept the same thing also, that there is a due of 150 US dollar also. So you have to pay off those 150 US dollars to enjoy the property which is worth of 100 US dollars. So it is up to you whether you want to accept it or not. That's what I said you, that why the acceptance by the donor is very important. So it is not just like that there is no consideration, anyone can give a gift to anyone. It is not such cases. The consent of the donor is very important. So you have to see into the gift if you're going to get the benefit or the burden out of it. So let's say the same property, 100 US dollar, there is a due of, let's say, 20 US dollar. You can easily get the gift. You have to just pay off the 20 US dollars. So 80 US dollars, you are in profit. You can take the gift. Next is universal donor, which comes under section 128. So where a donor makes the gift of his whole property, movable or immovable, without retaining anything for himself. So where the donor makes the gift of his whole property, movable as well as immovable, without retaining anything for himself, then the donee is called a universal donee. So where a person is making gift of his whole property, including both the movable as well as the immovable. So it is not that making all the immovable and keeping the movable, or gifting all his movable and keeping the immovable. So it has to be both the movable as well as the immovable property without retaining anything for himself. Then the donee, the person who is going to receive the gift, will be called as a universal donee. And the donee is liable, personally liable for all the debts and liabilities of the donor due at the time of gift. So let's say the gift is made on 1st Jan 2021. So the donee is liable for all the debts and liabilities which is due on that particular date. So let's say on 2nd Jan itself, the donor goes and gets some credit, or goes and gets some loan from someone. For that, the donee is not liable. But let's say the donor has taken some loan and all on the 31st of December 2020, then the donee is liable for that. So the donee is liable for all the liabilities. So it is vice versa. It is applied on the same concept of onerous gift, section 127. It is applied in the same nature. So that is, you cannot just like that enjoy the benefit in a transaction. You also need to enjoy the burden out of it. You need to have the, you have to bear the burden also in a property. Next is donations moritus causa, section 129. So which says that the section exempts two gifts, that is the Muslim gifts called as hiba, or the gift of movable properties made in contemplation of death. So this is called as bed death ridden gift. So any gift which is made at the time of the gift, that is what this section talks about. So in this video lecture, we have seen what is gift, definition of gift, which is very important, the essentials of gift, and as well as we have seen certain other concepts like how a gift is made, how a movable property can be transferred, how an immovable property can be transferred as a gift. We have also seen certain concepts and maxims under the onerous gift and the universal donee also. So students, thank you for your patience listening for this video lecture. Thank you.